Hello everyone, I'm Helen Ju, the legal advisor of EU SME Center. I joined the center since 2012. Today's topic is choosing and using agents for setting up and operating an FIE in China. We'll pass the introduction of the EU SME and go directly into today's topic now. First, FIE is the abbreviation of Foreign Invested Enterprise. And here, I'd like to clarify the concept of agent. An agent is not someone who knows Chinese language and just helps to fill in simple forms, standard application documents, and submits documents to authorities. They should be familiar with legal regulating in relevant industry involved and have years of experiences in providing relevant services in practice. The services should be value-added ones for foreign investors and FIE setup. We use FIE setup as an example to explain this issue. Many foreign enterprises, including EU SMEs, considering the huge market volume in China, would like to set up a company in China so as to have an entity on the ground to operate in the market. To do so, an issue appears. Do I need an agent for this, or can I, as a foreign investor, set up the FIE myself? My answer is yes and no. It depends on the specific situation. First, with respect to FIE setup on the websites of authorities, such as the branches of MOFCOM and the State Administration for Market Supervision, there are informing lists of documents required. In the center, we have a guideline. With such practical guidelines, information on specific requirements for documents by government branches. Such information enough, or do we still need agents? Let's see under what circumstances the answer is no. In practice, we may see ordinary wholly foreign-owned consulting companies or even wholly foreign-owned trading companies set up by the investors themselves. In simple circumstances, you can do it yourself. At least some conditions I believe that should be met if foreign investors want to do the setup themselves here. At least 6 conditions. There may be more. To give the answer, there's no need to engage agents. In my opinion, all these conditions need to be met. As you can understand, it is possible an ordinary wholly foreign-owned consulting or trading company meets all the conditions. But in most cases, the answer is yes, you need an agent. At least 2 circumstances. One, if you have limited time frame. Time begins to count only when all the documents meeting requirements are submitted. Authorities provide more detailed information on requirements on their websites now, but still sometimes rework is inevitable. So if it is very urgent, even though the circumstance is simple, you may want to consider hiring an agent to save time. If circumstance is not simple, in most cases, I would say yes, you need an agent, unless you have an in-house legal counsel experienced in foreign direct investment. Among all conditions, at least in the previous slides, others are easy to tell. But it's not easy to be sure of the first and second conditions. In case the FIE to be set up will have more than one investor, I've heard many times when setting up a JV, a foreign investor said, my Chinese partner will handle this or that. I trust my partner. Later on, when they broke up with their Chinese partner, the foreign investor may regret and say, I don't know that. It was handled by the Chinese partner. He cheated me. The truth is, In most cases, there is interest conflict between joint venture investors or different shareholders of a FIE. They have to balance and negotiate about their interests before the relevant documents such as shareholder agreement or JV contract can be finalized. When a dispute arises, if there are relevant provisions in the charter documents, there may be agreed rules to follow. It is better than there isn't, but drafting such documents requires knowledge and expertise of experienced legal professionals. That's a reason you may need an agent in this circumstance. I will spend more time on the issue of legal analysis in detail in next slides. I list here value-added services an agent can provide. I will give more detailed information to explain. For setup of an FIE, prior legal analysis is important. General legal analysis, like for foreign company, if it is necessary to set up a legal presence. If a rep office is enough or an FIE is needed. What types of FIE is needed? What business scope should be registered for the FIE? As for specific analysis, there are many. It may help investors to categorize the proposed FIE's business into the right industries. Check if the industry is open to foreign investment, what restrictions there are, and what special requirements to meet. If such an FIE can be allowed to be registered in the proposed place, what additional approvals should be required to be able to engage in the proposed business, the optimized plan for the investment, etc. Even though now procedures for FIE setup have been simplified a lot, in many cases, foreign investors still may not have a clue what approvals or filings may be needed, or how to get the approval for setup of certain FIEs. First, different from setting up a consulting or trading company, to set up a foreign investment manufacturing enterprise, you need to go through environmental impact assessment review and get the relevant approval, which may be complicated in terms of expertise. Second, foreign investment in restricted industries needs to be approved by provincial branch of National Development and Reform Commission. A foreign investor has to identify if his proposed investment is a restricted one. Last, to set up an FIE in specific industry, special prior or post-registration approvals may be required. For example, training institution setup needs prior approval from Education Authority or Human Resources and the Social Security Authority. One common inquiry received during work is, I want to set up a website in China to do this or that. First, we need to clarify. Foreign companies are not allowed to set up and operate websites in mainland China. To do so, a foreign company needs to set up a rep office or an FIE in China. Rep office as a non-profit making legal presence cannot engage in profit-making operations. In most cases, that should be an FIE. In many potential foreign investors' viewpoint, to set up an FIE may be simple, but a lawyer engaging in foreign direct investment would first think about if value-added telecommunications are involved in such cases and what value-added telecommunication license is needed in order to develop the proposed business via a website located in China. This has to be ascertained based on analysis of the proposed business model and research on relevant value-added telecommunications regulations, or even consultation with officials of the Ministry of Industry and Information Technology or its competent local branch. Prior legal analysis is the first step, also a very important step. Doing it well, a good agent can help investor clients to identify possible risks and difficulty and avoid suffering from reckless decisions. To achieve this, it requires efforts from both parties. As clients, you need to give information as much as possible. As an agent, it should be able to guide clients to share necessary information and help find real problems and suggest proper solutions. In addition, a good agent can help clients to plan from the whole process perspective, not just to enter the market. It may help work out best investment structure or even how to exit from the market in the future. There is an example which can help explain this. A foreign investor once set up a JV with a Chinese investor using its trademark for capital contribution. The foreign investor signed contracts with its clients supplying the product with such trademark and sourced the production to the JV. Later on, the foreign investor broke up with the Chinese investor. As the Chinese investor controls the operation of the JV, the foreign company changed to engage other Chinese companies to produce the products. The JV and the Chinese investor reported to the customs for infringement of trademark, and the goods cannot be exported to clients, resulting in serious breach of contracts of huge amount. Eventually, the foreign company went bankruptcy. In this case, if it consulted its agent and built up a safe zone at any link when setting up the JV, this consequence won't happen. By building up a safe zone at any link, I mean it may choose not using trademark for capital contribution to the JV, or it may keep its own using right of the trademark when negotiating with the Chinese investor, or it may design to control operation of the FIE at the time of its setup. But at that time, the foreign investor just focused on the FIE setup and did not realize its overall business may be affected by this reckless decision. As for communication, agents do have the advantage of better communication with authorities. I remembered when I worked in law firms that handled a merger and acquisition case. A foreigner bought the equity of an FIE and would like to change the factory address to another place. The employees hearing this raised objection to the transaction. Though legally speaking, consent of employees is not required, but approving authorities have to consider social influence and stability when they decide whether or not to grant the approval. The buyer didn't know how to deal with this. As a lawyer, I communicated with the client first and then accompanied him to meet the official making the explanation. Finally, the client got the approval. Communication with authority is important, but if an agent claims it has good relationship with certain authority and can handle all the things, even those in gray areas, I would suggest you be careful. Do not believe the so-called 关系 blindly. Effective communication is based on professionalism. It is so at least in first-tier cities like Shanghai and Beijing in China. Here, I will give two true examples in details. First, a foreign company would like to set up a subsidiary in China to engage in certain business. registration of an FIE was done and the business license was successfully obtained. The FIE employed many staff and started operation. Registered capital was contributed. 1 year later, the foreign investor found the business the FIE was engaging in should be classified into one sector of the value-added telecommunications, which is not open to foreign investment yet. So the operation of the FIE is illegal, even though it has obtained the business license. There is no chance for it to get the needed value-added telecommunication license from the Ministry of Industry and Information Technology. Transfer of equity won't be an option since its operation is illegal. Deregistration has to be the only solution, in which case they have to terminate all employment contracts and go through tax deregistration first. This could be time-consuming and costly. In addition, the business plan of the parent company may be affected a lot. Everything has to restore to its original status. They are exposed to risks of illegal operation in China, plus all the time and cost and business opportunity given up due to implementing the FIE setup and operation. The investor has to adjust his business plan. All these are because of a wrong start. So you can find out analysis and assessment before starting investment is not dispensable or negligible. It helps avoid being stuck in between or facing an established situation you cannot change but have to solve at huge cost. Imagine if they have got the important information before the investment. All this wouldn't happen. So look before you leap. My second example is this. Sometimes it is even suggested to think about exit before entry. Many foreign investors have the experience that exiting from Chinese market is more difficult than entering. When I worked with a law firm, an American investor took 2.5 years to deregister its FIE in Beijing. In practice, many foreign investors, when they exit from China, realized they should have thought about this when they entered. To EU SMEs, commonly seen ways of exit are deregistration of FIE or transfer of FIE equity. I have talked a bit about deregistration above. It is time-consuming, mainly at the link of tax deregistration. Accounting books and tax filing for previous 3 years will be examined. If the FIE has any historical tax issues, deregistration won't be finalized until solved. About exit by way of transfer equity of the FIE, it depends on industries involved. If MOFCOM approval or even National Development and Reform Commission's approval is required, it could be complicated. In such case, using a vehicle in a third jurisdiction like Hong Kong to indirectly invest in China can be considered. By simply transferring the equity of the direct investor instead of the equity of the FIE, the real investor do not need to go through the approval in mainland China. One reminder is, many years ago, some investors chose the indirect approach mainly for the purpose of tax planning. The vehicle was registered in a place which has a preferential tax treatment arrangement with mainland China. But now, tax administration in China is approving, and a vehicle without substantial operation will be seen as a conduit company and will be penetrated, and the indirect investment approach cannot serve the function of tax planning. But still, some investors would like to choose this approach to avoid complicated approval procedure when exiting from China. Setting up a vehicle as the direct investor and maintaining its existence may cause additional cost. If no approval from MOFCOM or National Development and Reform Commission is needed, transfer of equity just need alteration registration. In this case, direct investment is okay. If I need an agent, what kinds of agents I need? Set up and operation of an FIE may need various agents. They may help you save time and money eventually. As for what kinds of agents you may need, it depends on the services you need. At least some agent services that may be needed. It's not exhaustive. In the setup phase, an EU SME may need legal services for the setup. Prior legal advice, drafting documents like joint venture contracts or shareholder agreements. As explained above, it's important and valuable. If it is a trading company engaging in exporting, tax refund registration is needed. Otherwise, the FIE cannot enjoy tax refund for its export. If it is a manufacturing company, environmental impact assessment review is needed. A foreign investor needs to engage a preferential environmental assessment institution for this. To operate legally in some industries, an FIE needs to obtain certain approvals, registrations, or filings before it can actually engage in the business. In this case, you need assistance from agents. Some can be assumed by the lawyer helping to set up the FIE. Some may have to be done by special professionals other than lawyers. There are some common needs in the operation of a FIE in China. First, bookkeeping and regular tax filing. You may need to do the VAT filing monthly, CIT filing monthly, and also in the first 5 months of a year, the FIE may need to conduct annual reconciliation for the previous year. Also, bear in mind that companies in China need to meet deadline for tax filing. So professionals may be needed for this. About employment, recruiting and engaging employee in China. The PRC employment contract law began to be implemented in 2008. Since then, the labor law practice in China has a great development and legal protection of employees' rights and interests has been improved a lot. We all hope no disputes arising from employment, but once there is, it is a headache and may disturb the normal operation of the company greatly. So I suggest 2 things. Formulate and publish within the company a staff handbook properly and get in touch with employment lawyer in advance to have a backup when needed. Sometimes we received inquiries seeking assistance like, I had a labor dispute. Do you have suitable lawyer? When I worked with law firms, I once provided advice on employment issues in situations like doing research for regular company clients or doing due diligence for shareholding, merger and acquisition case. Equity transferee needs to know the possible risks in the employment aspect in case the target company does not have good employment administration. But I have to admit, with all this experience, I cannot say I'm an experienced employment lawyer. In my opinion, you had better engage lawyers having experience in employment areas for at least 6 or even better over 10 years to take care of your dispute case. Another issue to be noticed is interpretation of national employment-related laws and regulations in different cities may vary a lot in practice. Each province or city may have its own local regulations. A less experienced lawyer may spend a whole day doing research, but still the conclusion drawn may not be that precise. An experienced lawyer who works daily in this area may just need half an hour, and the advice can be very practical, not just based on regulations, but also based on local practice. Given these factors, you can see to find an experienced lawyer who knows local practice, who can communicate well in English, it's not that easy, especially in a short timeline. So please pay attention to availability of experienced employment lawyers in your operation place before disputes arising, and keep their contact information for a rainy day. You can even consult them on some issues such as proper daily employment administration to test their real capability. One day when needed, you won't fuss about finding one in a hurry. There are additional rules for engaging foreign employees. If an FIE involves engaging foreigners, you may need advice for visa, work permit, and resident permit. Since 2017, a new system was implemented in China for foreigners working in China. All foreigners working in China are classified into 3 categories, category A, B, and C. Administration for each varies. So special experts on this may be needed. As Chinese legal system is different from that in Europe, if the governing law in a contract is Chinese law, you may also need Chinese licensed lawyer or in-house legal counsel to do business contract review for you. If a commercial dispute arises, a litigation lawyer is needed. I won't talk in detail about this. Under some circumstances, law firms are needed. For setup of an FIE, most consulting companies have no problem with setting up a WFIE with single investor, which involves no complicated shareholders relationship or structured design. But when the latter is involved, prior analysis and design values a lot. Therefore, I would recommend law firms with experienced lawyers instead of consulting companies if the FIE to set up is a GV or is a WFIE with multiple shareholders, where shareholder interest needs to be balanced. Or it is proposed to engage in industry when complicated regulating system is involved. Or overall, transaction structure and route to invest needs to be considered. For employment issue, law firms are suggested. But most law firms do not practice much in tax area. In fact, few law firms are good at tax, as practice matters over interpretation of regulations from wording. In this aspect, as far as I know, professional consulting companies have advantages in both expertise and practice experience, as well as maybe fee level. For visa and work permit, residence permit, more consulting companies provide services in this aspect. If an IPR issue is involved, you may also need advice from professional IPR advisors, which could be law firms or professional IPR advisory companies. The operation of some FIEs may involve special industry or special products, such as pharmaceuticals. Specific registration is required. you may need to consider engaging an agent for such specific registration. Not many law firms have experience in providing such service. Usually it requires special expertise to provide the services, and some professional consulting companies may specialize in this area. To choose a proper agent, the following elements are suggested to be considered. First, capability, experience, qualification. Second, integrity, reliability. A third, locality. Fourth, price. I'll talk about these elements from beginning. Unqualified agent may do simply what you want and cannot do the analysis capably for clients. There are cases like this. A client told its agent, I want to set up a rep office. The agent said, okay, this is the list of documents you need to provide. Provide me with this and that documents, such as your certificate of incorporation. But they have no communication on the deeper commercial reasons of setting up this rep office. So after the setup, the client realized rep office could not engage in profit-making activities, but the client wants the Chinese legal presence to take payment and issue invoice. Rep office simply could not do that. In addition, a rep office cannot be changed to a FIE. At last, the client has to set up an FIE from scratch, and they have to close the rep office. As you can see, if they have enough communication beforehand, all these costs will be saved. Locality is important for employment cases, but it's not limited to such situation. In FIE setup cases, it also matters. Mentioning foreign direct investment, many people know there is a catalog of industries for guiding foreign investment. There are also some local regulations. For example, in Beijing, there is specific prohibition on setup or enlargement of companies engaging in certain industries such as shoes, clothes, and tobacco manufacturing companies. Agents practicing in other cities may not be familiar with this. We suggest one function of agent is effective communication with authorities, but as I suggest above, if an agent tells you it has so good relationship with relevant officials that it can help to handle all issues, including those in gray areas, please be careful. Its professionalism is doubtful. For price issue, from previous introduction, you can see price is not the first nor decisive factor. But still, to lower the price, you may consider flexible ways on this issue. For example, some law firms cooperate with consulting companies on FIE setup or deregistration. Foreign investors may sign service agreement with the firm, and in the agreement it can be agreed that the firm may outsource certain parts of their services to a third-party service provider, which will report to the firm, and the firm promises to be responsible to the foreign investor for all the services indicated in the agreement. This way, foreign investors may get a lower price since the cost of outsourced services can be lower if performed by a third party, but the firm's obligation towards investors remain the same. All foreign investors would consider bearing more risks. Say in a joint venture setup case, it can engage lawyers to do the prior legal analysis and drafting joint venture contract. As for other labor-intensive part of work, it may engage an ordinary consulting company to do so. such as preparing not so important documents such as application letter, appointment letter of directors, and submission of documents to authorities. Next, we come to the due diligence part. There are various sources to find agent. You may surf online and find one. There are also many famous law firms in China. You can visit their website. You may also ask for recommendation from a friend who once used the service of such agents. No matter what the sources are, I would suggest you do your due diligence on the potential agents yourself. This report of the center, the first one, Knowing Your Partners in China, it gives a comprehensive picture of how to conduct due diligence on potential partners. The first step is to ask for documents proving its legal registration and existence. Check its Chinese name on the document. If your agent is a consulting company, you may ask it to provide you with its business license. We list here the website of the National Enterprise Credit Information Publicity System. You can, as long as you have someone who can read and write Chinese, you can, with such assistance, you can do the online check to see if they are registered information on this official website is consistent with what they claim or what's indicated on the business license they provided to you. You can also, based on such information search, you can also verify if the duplicate business license received is a valid one. If your agent is a law firm, its registration certificate should be issued by the local Justice Bureau. We list here websites of Justice Bureau or Bar Association in Beijing, Shanghai, and Guangdong, where you can find their registration record. Here's a reminder, in China, many famous local law firms do not work as a team in terms of whole firm. Usually one partner of the firm may lead several lawyers to work as a team. There is internal cooperation among different teams inside a law firm, but not that close. Therefore, I would suggest to conduct due diligence on the specific lawyer who handles your case, not just the law firm. As for quotations and services, I would say about the service, your aim is to set up a company which can operate normally, not just a shell that cannot operate. Therefore, when considering services needed, it should include all services required for enabling the FIE operate normally, such as obtaining all the qualifications needed, being in a position to make payments and issue invoices. If it is a trading company engaging in exporting goods, necessary tax registration shall be in place so as to apply for tax refund, etc. Agents may tend to give a general service description, but I would suggest to get the breakdown of the services. It can be described by phase deliverables if suitable. You can have clear impression in the process that in which phase the FIE setup is and how many workloads are held. It is also good for management agents. Only Chinese documents are required by Chinese authorities. Documents formed outside of China, such as certificate of incorporation, need to be notarized by local notary in the foreign country and legalized by the Chinese embassy or consulate there. As most foreigners are not good at Chinese, if foreign investors want to learn the contents of the application documents signed and submitted, they need to require in their engagement agreement the bilingual language version of the document. If you have other requirements on the services or service provision, you had better provide them expressly in the engagement letter with the agent to avoid misunderstanding or disputes. As for service fees, there are several factors that may affect the service fee. I would suggest you make your decision based on clear and sufficient information. First, fees to be charged depend on the service workload. Comparing to others, an agent may quote low, but services covered may also be few. It makes no sense to talk about fee are high or low without defining the services. As for quotation breakdown corresponding to detailed service items, try to ask for a package quotation after learning the quotation for each specific service. Compare quotations for individual service items with package quotations. Second, ask an agent to give detailed information of specific service provision staff. Usually they will provide such information. Experience of such person affects both quality and cost of the services. Rich experience of good service providers and their professional attitude in handling cases may help clients with good planning and avoid rework. Accordingly, their quotation may be a bit higher. Third, note that place of service provision also makes difference. Normally, service fee in a second-tier city is lower than that in first-tier cities like Beijing and Shanghai. Now it comes to management of agents. Good management starts from choosing the right agent. Sufficient communication beforehand and in the process shall be ensured. Otherwise, the cost is unclaimed. You can see this in my previous explanation about prior legal analysis. To supervise agents and demand reporting. Last, contact the person handling a case directly if possible. At last, I list some tips here. One thing I've stressed here besides these tips is do not just tell your agent what you decide. Tell them what you want to do and listen to your agent's analysis and suggestion. And ask further if you have any doubts. That's what you pay them for. Besides the 2 reports guidelines mentioned above, I will recommend several additional guidelines that may be useful to the operation of the FIE from employment and tax perspective. Here's the link. You can find it at the website of the center. Okay, thank you for listening and hope this webinar will help you to set up an FIE in China and operate them properly. If you have any questions, please send them to us through the Ask the Expert at our website. Thank you for your time.